I never thought a hole in the ground would turn me into public enemy number one. But here I was, sitting in a courtroom facing a lawsuit because I refused to share my private well with the entire neighborhood. My name is Marcus Chen, and I bought my property in Boulder Creek, California, specifically because it came with its own natural spring. The house itself was nothing special, just a modest 3-bedroom ranch built in the 1970s, but that spring was pure gold. Crystal clear water bubbling up from deep underground, filtered through layers of granite and limestone, better than anything you could buy in a store. When I signed the papers 2 years ago, the real estate agent made it abundantly clear that the spring was entirely on my property, predating any HOA regulations by about 40 years. I had the surveys, the deed restrictions, everything in writing. The trouble started last summer when California hit another drought cycle. Nothing catastrophic, but enough that the county issued water conservation guidelines. Our HOA, led by the eternally irritated Brenda Hutchinson, decided this was her moment to shine. Brenda was exactly what you would picture. 52 years old, highlighted blonde hair always styled in that aggressive suburban mom cut, designer athleisure where that cost more than my monthly grocery bill, and a voice that could strip paint off walls when she got going. I was watering my vegetable garden on a Thursday evening when she first approached, her white Tesla humming to a stop in my driveway. She climbed out wearing pristine white sneakers that had clearly never seen actual exercise, carrying a clipboard like it was a holy artifact. "Marcus, we need to talk about your water usage," she announced, not even bothering with a greeting. I turned off the hose. "Hello to you too, Brenda. What about it? You're using significantly more water than anyone else in Ridgeview Estates. It's been noted." She tapped her clipboard meaningfully. "I'm watering my garden. It's legal. We're not under mandatory restrictions." Yet, she emphasized that word like a threat. "And when we are, your excessive usage will be a serious problem. Some of us are trying to be responsible community members." I bit back my first response and went with something more diplomatic. "Brenda, I'm using water from my private well. It doesn't affect anyone else's supply. It's not connected to the municipal system." Her eyes narrowed. "A private well on your property?" "Yes, it's been here since the 1960s. It's in all my property documents." I watched her expression shift from confusion to something that made my stomach sink. It was the look of someone who had just found a new crusade. "We'll see about that," she said, climbing back into her Tesla. "The HOA board will be reviewing this matter." That was 3 months ago. Since then, my life had become an absolute nightmare. The first letter arrived a week later, delivered by certified mail. The HOA demanded I attend a special session to discuss communal water resources during drought conditions. I showed up to find the community center packed with neighbors I barely knew, all staring at me like I had been personally stealing water from their taps. Brenda stood at the front with a PowerPoint presentation, an actual PowerPoint about my well. She had satellite images, water usage statistics for the neighborhood, and even photographs of my garden taken from the street. The whole thing felt surreal. "As you can see," she lectured, clicking to a slide showing my property outlined in red, "Marcus Chen's residence sits on a natural spring that produces approximately 500 gallons of fresh water per day. Meanwhile, the rest of Ridgeview Estates is struggling with hard water from the municipal supply and facing potential rationing." My neighbor Tom Brennan raised his hand. "I'm sorry, but isn't that Marcus's water? It's on his property?" "That's a narrow way of looking at it," Brenda snapped. "We're a community. Natural resources should benefit everyone, especially during a crisis." "What crisis?" I finally spoke up. "We're under voluntary conservation guidelines, not mandatory restrictions, and my well doesn't take anything from anyone. It's a separate water source entirely." Brenda smiled, and it was not a friendly expression. "Actually, Marcus, according to California water rights law, all groundwater is subject to reasonable use doctrine. You can't hoard a natural resource just because it happens to emerge on your property." She had clearly been doing research, but she was twisting the facts. That applies to excessive or wasteful use, I countered. I'm using my water for normal household purposes and a small garden. That's textbook reasonable use. 500 gallons a day for one person is not reasonable, she shot back. I'm not using 500 gallons a day. The spring produces that much, but most of it flows through my property into the creek bed like it has for decades. I'm using maybe 50 gallons a day from it. The murmuring from the crowd suggested some people were starting to see reason, but Brenda wasn't done. Nevertheless, the HOA board has voted to require all residents to share water resources equitably during drought conditions. We're implementing a new community water sharing protocol and will need access to your well to connect it to a distribution system. Absolutely not, I said flatly. You have no legal authority to access my private well. It's not an HOA amenity. It existed before this HOA was even created. Then you'll be in violation of HOA regulations, Brenda said triumphantly, which carries a fine of $500 per day until compliance is achieved. That's when I realized this wasn't about water conservation. This was about control. Brenda couldn't stand that someone in her domain had something she couldn't regulate. I hired a lawyer the next day. David Shepard was a property rights attorney based in San Jose who had dealt with HOA disputes before. He was a tall, perpetually tired-looking man in his 40s who listened to my story while drinking what appeared to be his fourth coffee of the morning. You have documentation proving the well predates the HOA? He asked. Yes. The property survey from 1968 shows the spring. The HOA wasn't established until 1995. And your CC and Artiques, any mention of shared water resources, I pulled out my copy of the covenants, conditions, and restrictions. Nothing. Water isn't mentioned except for a standard clause about not wasting municipal water during emergencies. David nodded, making notes. Okay, here's the situation. They can't legally force you to share your well. It's your property, it predates their authority, and California law protects pre-existing water rights. However, HOAs can make your life miserable with procedural harassment. We need to shut this down fast and hard. He drafted a cease and desist letter citing specific property law statutes and delivered it to the HOA board. I thought that would be the end of it. I was wrong. Brenda's response was to escalate. Suddenly, I was receiving violation notices for everything imaginable. My trash can was 6 inches over the property line on collection day. My lawn was 1 inch taller than HOA standards allowed. My mailbox was the wrong shade of black. Each violation came with a $50 fine. Then the really petty stuff started. Someone kept reporting my car as abandoned if I parked it on the street overnight, even though that was completely legal. I would wake up to find orange tags on my windshield threatening to tow it. My packages started disappearing from my porch. Someone filed a noise complaint claiming I was running loud machinery at midnight, which was impossible since I was provably at a movie theater with time-stamped tickets. Tom Brennan caught me checking my mail one afternoon and pulled me aside. "This is getting ridiculous," he said quietly. Half the neighborhood thinks Brenda has lost her mind, but the other half believes her propaganda about you hoarding water. "I'm not hoarding anything," I said, frustrated. "The water flows through my property whether I use it or not. It's not like I'm damming it up." "I know that. You know that." "But Brenda has people convinced that you're the reason their water bills are high and their lawns are dying." "Their lawns are dying because we're in California and they're trying to maintain Kentucky bluegrass in a drought. That has nothing to do with me." Tom nodded sympathetically. "You're preaching to the choir. Just watch your back. Brenda's telling people that if you won't share voluntarily, the HOA will take legal action to force you." 2 weeks later, I was served with a lawsuit. The paperwork was delivered by a process server who looked apologetic as he handed me the thick manila envelope. "Ridgeview Estates Homeowners Association versus Marcus Chen," he said. "You've been served." I called David immediately. "They're actually suing me, Bring the papers to my office. Let's see what they're claiming. The lawsuit was even more absurd than I had imagined. The HOA was alleging that my monopolization of natural water resources violated my obligations to the community, caused undue hardship to other residents, and constituted a nuisance under California law. They were seeking a court order to force me to install a distribution system connecting my well to the neighborhood, with all costs to be borne by me. They estimated this system would cost approximately $80,000. David read through the filing with increasing disbelief. This is one of the most legally baseless complaints I've seen in 10 years. They're essentially arguing that you should be forced to give away your property and pay for the privilege. Can they do this? They can file whatever they want. Doesn't mean they'll win. In fact, I'm confident we can get this dismissed, but it's going to cost you legal fees and it's going to be stressful. He wasn't kidding about the stress. The lawsuit became public record, and suddenly I was the neighborhood pariah. People who had been friendly before now crossed the street to avoid me. Someone spray-painted "water thief" on my garbage can. I found a dead rat in my mailbox one morning, which was disturbing enough that I filed a police report. Deputy Maria Gonzalez came out to take my statement. She was a no-nonsense woman in her 30s who had clearly dealt with HOA drama before. "Let me guess," she said, photographing the dead rat. "HOA dispute. How did you know?" "Because 90% of harassment calls from this neighborhood involve HOA disagreements. We had a case last year where neighbors were feuding over fence height and someone put dog feces in the other guy's pool skimmer. People lose their minds over this stuff. It's about my well. The HOA wants me to share it with the neighborhood." She looked up from her notes. "Your private well. The one that's been on your property for decades. That's the one. And they think they have a right to it, apparently. They've sued me." Maria shook her head. "I'll file this report, but between you and me, you should document everything. Every interaction, every incident, every violation notice. If this escalates to stalking or more serious harassment, you'll want a paper trail." Her words proved prophetic. The harassment intensified as the court date approached. Someone slashed 2 of my tires. My garden hose was cut into pieces overnight. I installed security cameras and caught footage of a teenager I didn't recognize throwing eggs at my windows at 2 in the morning. When I turned the footage over to the police, they identified him as Brenda's nephew, staying with her for the summer. Deputy Gonzalez brought the kid in for a conversation, and I decided not to press charges when his parents agreed to pay for the damages, and he delivered a clearly coached apology. But it confirmed what I suspected. Brenda was orchestrating at least some of this harassment. The preliminary hearing was set for September 14th in Santa Clara County Superior Court. David had filed a motion to dismiss, arguing that the HOA had no legal standing to sue over my water rights. Judge Patricia Morrison would be hearing the case. I arrived at the courthouse early, wearing my only suit and feeling like I was going to throw up. David met me outside, carrying a briefcase full of documents. "Remember, don't speak unless the judge asks you a direct question. Let me handle the legal arguments. You just need to be present and look respectable." Brenda arrived with what appeared to be half the HOA board in tow, all dressed like they were attending a funeral. She had hired a lawyer named Richard Thornton, a slick-looking guy in an expensive suit who apparently specialized in real estate litigation. Judge Morrison was a woman in her 60s with steel gray hair and an expression suggesting she had heard every ridiculous argument known to mankind. She listened impassively as Thornton made his opening statement. "Your Honor, this case is about community responsibility and the equitable distribution of natural resources. Mr. Chen has access to a natural spring producing hundreds of gallons of fresh water daily, while his neighbors struggle with poor quality municipal water and face potential rationing. Under California's reasonable use doctrine and the principles of community living embodied in HOA agreements, we believe Mr. Chen has an obligation to share this resource. Judge Morrison turned to David. Counsel, Your Honor, this case should be dismissed immediately. The spring in question is located entirely on Mr. Chen's private property, predates the HOA by nearly 3 decades, and is not mentioned in any HOA governing documents. The HOA has no authority over pre-existing natural features of individual properties. This lawsuit is a thinly veiled attempt to seize private property without compensation, which violates both state property law and constitutional protections against takings. Mr. Thornton, the judge said, does the HOA's authority extend to natural features that existed before the HOA was created? Your Honor, once property becomes part of an HOA, all aspects of that property become subject to community regulation for the greater good. The fact that the spring predates the HOA is irrelevant if it affects the community's welfare. That's not how property law works, David interjected. Pre-existing rights are grandfathered in. The HOA can't retroactively claim authority over something that was there first. That would be like claiming they could regulate the number of trees on a property because trees affect the community's air quality. Judge Morrison made notes. I'm inclined to agree with the defense. Mr. Thornton, can you cite any California case law supporting your position? Thornton fumbled through his papers. Your Honor, we believe this is a novel application of community welfare principles. Novel meaning unprecedented, meaning you're making it up, the judge said dryly. Mr. Shepard, anything else? Only that my client has incurred significant legal fees defending against a frivolous lawsuit and will be seeking recovery of those costs. Judge Morrison nodded. I'm dismissing this case with prejudice. The HOA has no standing to sue over water rights to a private well. Mr. Chen's property rights are clear and unambiguous. Furthermore, I'm ordering the HOA to pay Mr. Chen's reasonable attorney fees. Mr. Thornton, I suggest you advise your client to cease this harassment immediately. I felt a wave of relief so intense I nearly collapsed. David squeezed my shoulder. We won. But as we left the courtroom, Brenda's expression told me this wasn't over. She looked absolutely furious, whispering intensely with Thornton in the hallway. I caught fragments of their conversation. Appeal, Water Rights Board, environmental impact. David noticed my concern. Don't worry about it. They have no grounds for appeal, and any complaint to other agencies will be dead on arrival. You're protected. The attorney fees came to $12,000, which the HOA board had to pay out of the Community Reserve Fund. This did not make me popular. I received dozens of angry letters from neighbors complaining that I had stolen their money by forcing the HOA to sue me. The logic was impressively backwards, but I also started hearing from the reasonable contingent. Tom organized a recall petition to remove Brenda from the HOA board, gathering signatures from residents who were tired of her authoritarian approach. A woman named Jennifer Kim, who lived 3 streets over, stopped by with homemade cookies and an apology. I'm sorry I believed the rumors, she said. Brenda made it sound like you were literally draining an aquifer or something. When I actually looked into the facts after the court case, I realized how ridiculous the whole thing was. I appreciate that, I said, accepting the cookies. It's been a rough few months. She's done this before, you know. Last year, she tried to force the Hendersons to cut down a 100-year-old oak tree because it was blocking the community aesthetic. Before that, she sued someone for installing solar panels without HOA approval, even though state law explicitly protects that right. She just can't help herself. The recall election was scheduled for November. In the meantime, I finally enjoyed some peace. The harassment stopped, probably because Brenda's lawyer had warned her that any continued retaliation could result in additional legal consequences. I spent October improving my garden, installing a small greenhouse, and actually getting to know some of my neighbors beyond superficial waves. Turned out most of them were perfectly reasonable people who had just been manipulated by Brenda's fear-mongering. Then the first week of November brought something unexpected. A knock on my door from a very official-looking man in a suit carrying a badge. Mr. Chen. I'm Special Agent Robert Hayes with the California Department of Water Resources, Criminal Investigation Division. My stomach dropped. Criminal investigation? May I come in? I have some questions about your property and your well. I let him in, my mind racing through every possible thing I could have done wrong. Had I violated some permit requirement? Was there some registration I had missed? Agent Hayes sat down at my kitchen table and pulled out a folder. Mr. Chen, we've been investigating a complaint filed by your HOA regarding illegal water extraction and potential environmental damage caused by your well. That case was dismissed in court, I said. The judge ruled the HOA had no standing. I'm aware of the civil case. This is a separate matter. The HOA filed a complaint with our department alleging that you're extracting water at rates that could damage the local aquifer and affect neighboring properties. They've provided what they claim is evidence of environmental harm. He showed me photographs. My property, taken from various angles. Charts and graphs I didn't understand, and a hydrological report that allegedly showed my well was depleting groundwater levels across the neighborhood. This report is complete fiction, I said. My well is a natural spring. It's been flowing at the same rate for 60 years. I'm not extracting anything with pumps. The water comes up on its own and most of it flows right through into the creek bed. I understand, but I'm required to investigate the complaint. I'll need to inspect your well and take some measurements. Do you have a warrant? I can get one, but I was hoping you'd cooperate voluntarily. If you have nothing to hide, an inspection will clear this up quickly. I called David, who confirmed I should let the agent inspect. Better to cooperate and prove there's nothing wrong than to look obstructive. Agent Hayes spent 2 hours examining my well, taking water samples, measuring flow rates, and checking the geology. He interviewed me about my water usage, my property history, everything. He was professional but thorough. A week later, he came back with his report. Mr. Chen, I found no evidence of illegal extraction or environmental damage. Your well is exactly what you said it is. A natural spring with consistent flow rates that have remained stable for decades. The water flows through your property at approximately 450 gallons per day, of which you use about 40 to 60 gallons. The rest continues downstream as it always has. There's no impact on the local aquifer. So the HOA's report was false. His expression hardened. The HOA's report was completely fabricated. The data doesn't match any real measurements. The graphs appear to be digitally created rather than based on actual field work. And the hydrologist who supposedly authored it doesn't exist. I checked with every licensed hydrologist in California. No one by that name has credentials. They made it up. That would be my conclusion, which is a crime. Filing a false report with a state agency is a misdemeanor, potentially a felony if it's part of a pattern of harassment. I'm forwarding my findings to the district attorney's office for possible prosecution. I sat down heavily. This has gotten completely insane. Mr. Chen, in my 15 years investigating water rights violations, I've never seen an HOA go this far. Usually they give up after losing in civil court. Fabricating evidence for a criminal complaint is a different level of obsession. Agent Hayes was true to his word. The Santa Clara County District Attorney's Office opened an investigation into the HOA's false report. Assistant District Attorney Rachel Ortiz was assigned to the case, and she took it seriously. We have zero tolerance for people weaponizing state agencies, she told me during an interview. If someone files a false report to try to hurt another person, that's criminal harassment and abuse of the legal system. The investigation revealed that Brenda had paid someone $5,000 to create the fake hydrological report. The someone turned out to be her brother-in-law, who worked in graphic design and had created professional-looking documents based entirely on fabricated data. When confronted by investigators, He initially lied but eventually admitted the truth when faced with potential charges of conspiracy and fraud. The HOA recall election happened in mid-November. Brenda was removed from the board by a vote of 72%. Tom Brennan was elected the new president, along with two other reasonable board members. One of Tom's first acts was to issue a formal apology to me on behalf of the association and to rescind all the bogus violation notices and fines. "We're supposed to be making this neighborhood better, not terrorizing people," he said at the meeting. "What happened to Marcus was wrong, and it's never happening again on my watch." But the legal consequences for Brenda were just beginning. In January, the district attorney filed criminal charges against her and her brother-in-law for filing a false government report, criminal harassment, and conspiracy to commit fraud. Each charge was a misdemeanor, but combined they carried potential jail time and significant fines. The criminal trial was scheduled for March. Unlike the civil case, this one felt heavier. This wasn't about money or property rights anymore. This was about holding someone accountable for trying to destroy another person's life over a petty dispute. I sat in the courtroom as witnesses testified. Agent Hayes explained how he had uncovered the fabricated report. Brenda's brother-in-law testified as part of a plea deal, admitting he had created fake documents at Brenda's request. Deputy Gonzalez testified about the pattern of harassment complaints I had filed over the months. David had warned me that even with strong evidence, convictions in cases like this weren't guaranteed. Juries sometimes have sympathy for HOA boards because they think they're just volunteers trying to help the community. They don't always see the harm, but this jury saw it. After 3 days of testimony and 4 hours of deliberation, they returned guilty verdicts on all counts. Judge Morrison, the same judge who had dismissed the civil case, handled the sentencing. She did not look pleased. "Miss Hutchinson, you held a position of trust in your community. Instead of serving your neighbors, you used that position to wage a personal vendetta against someone whose only crime was exercising his legitimate property rights. You filed false reports with state agencies, wasting government resources and attempting to criminalize innocent behavior. You orchestrated a harassment campaign that included property damage and threats. This behavior is not only illegal, it's morally reprehensible." She sentenced Brenda to 6 months in county jail, 3 years of probation, 500 hours of community service, and ordered her to pay restitution covering my legal fees from the criminal investigation. The brother-in-law got probation and community service as part of his plea deal. Brenda's face went pale as the bailiff led her away in handcuffs. Her husband, who had sat silently through the trial, looked devastated. I felt no satisfaction, only exhaustion. This whole nightmare had consumed nearly a year of my life over something that should have been a non-issue. In the parking lot afterward, Tom caught up with me. "I hope this is finally over for you." "Me too. I just want to go back to living a quiet life." For what it's worth, a lot of people in the neighborhood have learned a valuable lesson about HOA power and the importance of keeping reasonable people in charge. We're rewriting a bunch of our bylaws to prevent this kind of abuse from happening again. That was something, at least. The story didn't end there, though. In April, a reporter from the San Jose Mercury News contacted me about writing an article on HOA overreach and the dangers of unchecked community association power. I was reluctant at first, but David encouraged me to do it. "Your story illustrates important issues about property rights and HOA governance. It could help other people who are going through similar situations." The article came out in May with the headline, "When HOAs Go Too Far: How One California Man Fought Back Against His Community Association and Won." It detailed the entire saga from Brenda's initial confrontation to her criminal conviction. The response was overwhelming. I received hundreds of emails from people across California and beyond, sharing their own HOA horror stories. A law professor at UC Berkeley contacted me about using my case in a property law seminar. A state legislator reached out to discuss potential reforms to HOA governance laws. The attention was uncomfortable, but it felt meaningful. Something good was coming out of all the chaos. Life gradually returned to normal. My garden flourished with the reliable spring water. I got to know my neighbors as actual friends rather than just faces I waved at. The new HOA board focused on practical issues like street maintenance and community events, rather than petty enforcement and personal vendettas. Brenda served 4 months of her sentence with good behavior credit and was released in July. I saw her once from a distance, loading boxes into a moving truck. Her husband had apparently decided they needed a fresh start somewhere else. She didn't look my way and I didn't approach. There was nothing left to say. Tom organized a neighborhood barbecue in August to celebrate what he called the new era of reasonable governance. Someone made a joke about me bringing spring water, and I actually laughed. The whole situation had become absurd enough that humor was possible now. "You know what the craziest part is?" I said to Jennifer Kim, who had become a good friend. "If Brenda had just left me alone from the start, none of this would have happened. I would have been happy to let neighbors fill up water jugs from my spring during a real emergency. But you can't force generosity. The harder she pushed, the more I had to fight back." "That's the thing about people like her," Jennifer said. "They can't stand the idea that someone isn't under their control. It's not really about water or rules or the community, it's about power." She was right. The whole conflict had been about Brenda's need to dominate, to be the person everyone had to ask permission from, to have authority over every aspect of the neighborhood. My well represented something outside her control, and that was intolerable to her. The drought eased that fall with unusually heavy rains. The creek that ran through my property swelled to its highest level in years, fed by my spring and dozens of other natural sources. The municipal water restrictions were lifted. Everyone's lawns recovered. The crisis that had supposedly justified Brenda's crusade evaporated like it had never existed. I spent a weekend in October building a small seating area by the spring, a quiet spot where I could sit and listen to the water. It had been there long before I bought the property, and it would be there long after I was gone. That perspective felt important somehow. David stopped by in November with final paperwork closing out all the legal matters. Everything's resolved. The restitution has been paid, the court orders are fulfilled, and there are no remaining claims or appeals. You're officially done with all of this. "Thank God," I said. "What do I owe you for everything?" The HOA and Brenda covered most of it through the court orders. "Your final bill is about $3,000 for the hours that weren't included in the judgments." I wrote him a check, grateful it wasn't worse. "Thanks for sticking with me through all of this." That's what we do. Besides, this was one of the more clear-cut cases I've handled. Usually, HOA disputes are full of gray areas and competing legitimate interests. This was just straight-up harassment and abuse of power. After he left, I walked out to my garden. The vegetables had finished for the season, but I had planted winter greens that were coming up nicely. I turned on the hose, watching the crystal-clear spring water flow over the lettuce and kale. It occurred to me that I had never taken this water for granted, but I had also never fully appreciated what a gift it was until someone tried to take it away. Not just the physical water, but what it represented: independence, self-sufficiency, a connection to the land that transcended property lines and legal documents. The spring had been here since long before humans built houses and created homeowner associations. It would continue flowing long after all of this drama was forgotten. There was something comforting in that permanence. I thought about Brenda sometimes, wondering if she had learned anything from the experience or if she was already finding new battles to fight in whatever neighborhood she had moved to. I hoped she had found some peace, but I doubted it. People that committed to controlling others rarely changed. For me, the whole ordeal had taught lessons I hadn't expected. about community and how fragile it could be when the wrong person gained power, about the importance of standing up for your rights even when it was difficult and expensive, about the difference between legitimate governance and petty tyranny. The new HOA board proved that community associations could function properly when led by reasonable people. Tom and the others focused on maintaining common areas, organizing social events, and handling practical issues like drainage and street lighting. They enforced rules fairly and consistently without playing favorites or targeting people they didn't like. It was mundane and boring, which was exactly what an HOA should be. In December, the neighborhood held a holiday party at the community center. I brought cookies and actually enjoyed myself, chatting with neighbors about normal things like work and family and holiday plans. No one mentioned the lawsuit or the well or any of the drama. It was blissfully ordinary. As I was leaving, Tom pulled me aside. "Hey, I wanted to let you know that the board has been discussing long-term water planning for the community. Real planning, not Brenda's crazy schemes. We're looking at rainwater collection systems for the common areas and drought-resistant landscaping. Nothing that would affect private properties, just ways to be smarter about water use." That sounds reasonable. And if there ever was a real emergency, like a major earthquake that disrupted water supplies, would you be willing to let the neighborhood access your spring temporarily? We wouldn't install any permanent connections or anything, just emergency access. I thought about it for a moment. Yeah, I could agree to that. Draw up something in writing that specifies it's purely emergency access, no permanent infrastructure, and that my property rights remain unchanged. I'll sign it. Perfect. That's exactly the kind of community cooperation that should have happened from the start. He was right. A simple conversation, mutual respect, clear boundaries, everyone's rights protected. That's how it should have worked all along. The written agreement was finalized in January, reviewed by David to ensure my rights were protected, and approved by the HOA board. It specified that in the event of a declared emergency disrupting normal water supplies, residents could access my spring for drinking water only, using their own containers, with no modifications to my property. It would terminate automatically once normal service was restored. The agreement also explicitly stated that it created no precedent for future claims against my property rights. I signed it and filed it away, doubting it would ever be needed but satisfied that reasonable people had reached a reasonable accommodation. Life continued. Spring came again, my second full year in the house. I expanded my garden, adding fruit trees and berry bushes that would take years to mature but would eventually create a small, edible landscape. The spring kept flowing, steady and reliable, the heartbeat of my little piece of California. I ran into Jennifer at the farmer's market in March, and she mentioned that Brenda's house had sold. A young couple with 2 kids had bought it. "They seem nice," she said. "Normal. The dad told me they were excited to find a neighborhood with an active HOA that does fun community events." "Let's hope they never learn the history," I said. "Oh, I'm sure someone will tell them eventually, but maybe it's a good cautionary tale. This is what can happen when communities make bad leadership choices." She was probably right. Every neighborhood had its legends and cautionary tales. Mine would be about the HOA president who went to jail trying to steal someone's water. I saw the new neighbors a few days later, moving boxes into what had been Brenda's house. The kids were running around the yard, excited about their new home. The mom was directing the movers with calm efficiency. The dad noticed me watching and waved. I waved back, hoping they would have a better experience with Ridgeview Estates than I had initially. Tom organized a welcome barbecue for them, and I attended, bringing my standard contribution of cookies. The new neighbors, Dan and Lisa Martinez, were indeed normal, friendly people who had moved from San Diego for Dan's job in tech. They had no idea about the drama that had unfolded in their new home. "How long have you lived here?" Lisa asked me. "About 2 years. It's a good neighborhood." "Quiet, friendly?" The HOA board is reasonable, which isn't always the case. That's good to hear. We've heard HOA horror stories from friends, sounded like a nightmare. It can be, I said carefully, but this one is well run. I decided not to mention that it had only become well run after the previous president was criminally convicted. Some things could wait. As spring turned to summer, I settled into a rhythm that felt sustainable and peaceful. Work, garden, neighbors, occasional social events. The lawsuit and all its associated chaos became something that had happened rather than something that was happening. The difference in my stress levels was remarkable. I even started dating someone, a woman named Amy I met through a hiking group. When she asked where I lived and I mentioned Ridgeview Estates, she laughed. "Oh, I read about that neighborhood. Wasn't there some crazy story about an HOA president who went to jail?" "Yeah," I admitted. "That was my HOA. I was the guy she sued." Amy's eyes widened. "You're the well guy." "That was you, guilty as charged. Or actually, not guilty as dismissed, but yeah." She wanted to hear the whole story, and I found I could finally tell it without getting angry. It had become an interesting anecdote rather than an open wound. We laughed about the absurdity of it, the pettiness, the escalation that made no sense. She asked good questions and was appropriately outraged on my behalf. "The thing that gets me," she said, "is that she could have just asked nicely. You probably would have shared if she hadn't been such a tyrant about it." "Probably, but people like that don't ask, they demand." Amy became a regular presence in my life, and she loved the spring. She would sit by the water reading while I worked in the garden, sometimes trailing her hand in the cool flow. "This is magical," she said one afternoon. "I can see why you fought so hard to protect it." "It wasn't really about the water," I said. "It was about not letting bullies win." Sometimes they're the same thing. By the time fall arrived, I felt like I had finally reclaimed my life completely. The anniversary of Brenda's first confrontation passed without me even noticing until Tom mentioned it at a board meeting I attended. "Hard to believe it's been a year since all that craziness ended," he said. "Feels like ancient history now." "Good," I said. "That's exactly where it should be." The neighborhood continued to thrive under sensible leadership. Property values held steady. People actually wanted to move to Ridgeview Estates now because it had a reputation as a well-managed community. The irony wasn't lost on anyone who knew the history. I never saw Brenda again. I heard through neighborhood gossip that she and her husband had moved to Oregon, trying to start fresh somewhere nobody knew their story. I hoped it worked out for them, or at least that she had learned something from the experience. But that wasn't my concern anymore. My concern was my garden, my spring, my life that I had built here. The water kept flowing, crystal clear and constant, a reminder that some things were worth fighting for and that sometimes, against all odds and in the face of determined opposition, justice actually prevailed. On a cool evening in October, I sat by the spring with Amy, listening to the water and the wind in the trees. "You know what's funny?" I said. "I almost didn't buy this house. I was looking at another property without an HOA, but I loved the spring so much I couldn't pass it up. No regrets." Amy asked. I thought about everything that had happened. The lawsuit, the harassment, the stress, the legal fees, the months of conflict and uncertainty. And then I thought about the friends I had made, the lessons I had learned, the satisfaction of standing up for myself and winning, and the peace I felt sitting here now. "No regrets," I said. "It was worth it." The spring bubbled up from the ground, flowing through my property and into the creek beyond, just as it had for centuries, and would for centuries more. It didn't care about HOAs or lawsuits or human drama. It just flowed, constant and pure, belonging to itself and to the land, regardless of who held the deed. And somehow, that felt like the truest victory of all.